Hey everybody, it is 2A Tuesday here on Freedom Steel. Todd Vandermine, and we have breaking news out of Texas. So hello everybody, welcome back to another edition of Freedom Steel. Todd Vandermine, former NRA contract lobbyist, Illinois gun law guru, and we have breaking news coming out of the 5th District in Texas. So on this great 2A Tuesday, boys, this is one that's going to rock your socks. So we have an injunctive decision by District Court Judge Reed O'Connor in the Mock versus Garland challenge to the ATF pistol brace rule. And there's a lot to unpack in these 38 pages, but I'm not going to unpack the whole decision. I'm going to hit some highlights that are important to us, and I'm going to particularly focus on the right to repair because it appears that Justice O'Connor has figured out the right to repair in a very short-handed way that could impact Illinois, amongst a few other things. So we're going to talk about those impacts, and let's just get straight away with it. And it is such a 2A Tuesday that we're going to hoist one, and we'll have some more comments about that a little later. God love liquid corn and ice croutons. So let's jump down here to footnote 16 in Justice O'Connor's decision here. But for the purposes of assessing plaintiffs' overall entitlement to preliminary injunctive relief based on the remaining factors on remand, the court finds it probative to discern the extent or degree to which the final rule threatens irreparable constitutional injury to plaintiffs' right to armed self-defense. So here, let's back up just a moment. Remember, this case had gone up to the 5th Circuit Court of Appeals, and the 5th Circuit Court of Appeals issued an injunction and then remanded it back for further proceedings down to the district court. So in citing that, Justice O'Connor said the 5th Circuit remanded the case back to the court with instructions to assess the remaining preliminary injunction factors and rule on plaintiff's motion. In light of the circuit panel's decision, and within 60 days thereof, the 5th Circuit placed, quote, no limitation on the matters that the court may address on remand, end quote, and no indication of what decisions it should reach. The important thing there is the appellate court, the upper court, did not put any handcuffs on what the district court could look at. And so they looked at a number of factors to include a 2A issue. They didn't find per se on 2A grounds, but what they did is they used it. They used the impairment of the Second Amendment as how you qualify for injunctive relief. That there is an impingement, there is irreparable harm by the infringement in the taking away of a constitutional right. And so there's a lot to unpack here, and there are 2 or 3 particular issues that would impact the Illinois law. For instance, he goes on here on page 18. As a per se matter, semi-automatic pistols are commonly used weapons for lawful self-defense purposes across the United States today. So what happens? Remember, common use is one of the test factors as illuminated by the Heller decision and reiterated within Catano and the New York decision. And so here, he's applying those tests. And in part of this, the government defendant's assertion to the contrary, that pistols do become dangerous and usual as soon as stabilizing braces are attached to them, does not survive its own administrative record. Remember that? They are trying to say dangerous or unusual. The judge here gets it absolutely right. Dangerous and unusual. And by virtue of them being in common use, they cannot be dangerous or unusual. But here, let's get to this. Remember how in some of my live videos, and I even did a special video on right to repair. The concept is that if you take New York, that if the conduct is protected under the Second Amendment, those 27 words, then it is presumptively protected conduct. The burden then shifts to the state to prove that their regulation fits with text and history and tradition, to show that the conduct would be allowed, the regulation of the conduct would be allowed by our founding fathers. And then if we jump back to the Ezell decision, hat tip to Mrs. Ezell, my friend, Ezell said you had the right to acquire guns and you had the right to train and maintain proficiency. My theory, my argument, is if you have a right to maintain proficiency, you have the right to maintain a firearm in good working order. If you have the right to maintain a firearm in good working order, you have a right to assemble a firearm out of parts that you acquire. And if you have the right to assemble a firearm, you then have the right to build a firearm. If you have the right to build a firearm, you therefore have the right to manufacture your own firearm if you have the tools, skill, and ability to do so. And so our job going forward is to make the 27 words of the Second Amendment look like the frickin' Encyclopedia Britannica. That all this conduct, so we have the right to acquire, which has to come with a corresponding right to sell. They say there's no right to sell a semi-automatic AR-15. Bullshit. If you can acquire one, there has to be a right to sell. And then, as Ezell also said, we had the right to train and maintain proficiency, to practice with our guns, which means we have to have ammunition to practice with our guns. And therefore, if we have the right to practice, we have to have the right to train with operable firearms, not blue guns, not airsoft guns, not squirt guns, not Nerf guns, but real guns. And we all know guns are mechanical objects that sometimes break. So we have to have the right to maintain them and keep them in good working order for our safety and for others. And we build from there. And so here today, this court, for the first time that I shouldn't say that. Judge Benitez did a passing in this, that barrels, triggers, and whatnot in his Duncan decision 2 weeks ago are not mentioned in the Second Amendment, but guns would be useless without them. He's absolutely right. But here we have a judge going a step further. And to quote him on page 20, the Supreme Court has already established that the text and history of the Second Amendment's operative clause, quote, the right of the people to keep and bear arms, end quote, protect an individual's right to possess, carry, and, ding, 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 hat tip, here's my ode to Mark Smith at 4 boxes, and operate a commonly used handgun. Operate in the home and in public for the lawful purpose of immediate self-defense. Operate, all right? So then he goes on. The Second Amendment also presumptively protects the FPC's member proposed course of conduct insofar as it involves, quote, making common safety improving modifications to otherwise lawfully bearable arms, end quote, for the purposes of enhancing performance of self-defense. There it is, right there. Making common safety improving modifications. The right to improve, the right to repair your firearm. The state has sat there in our cases in Illinois and argued that you have no right to the attachments, no right to the parts, that, pistol grips make them dangerous, and that, even though it improves that, they made all those BS arguments. Everything they argued has been disemboweled. This is the state might as well just go out and do seppuku. Here you go. This is done. The judge said we have a right to modify our guns. which means there has to be the corresponding right to keep our guns in well-working order. So let's continue on. The conduct of acquiring, attaching, and maintaining rearward attachments, such as a stabilizing brace, serves to make the pistol more stable and thus the user more accurate. And as explained earlier, accuracy in turn promotes safety in the real-life exercise of armed self-defense. The successful performance of armed self-defense entails not only deterring or neutralizing life-threatening perpetrators, but also preserving innocent life and preventing bodily injury to others as much as possible. Users directly advance these fundamental ends of self-defense when they modify lawfully bearable pistols with a rearward attachment that is a brace or a stock. Here, modify. Exactly what I have been arguing over these last 9 months. What I've argued, what our lawyers have put in the briefs, and the point that we're the only case in the country that has been making this on a semi-auto ban. And here it is. They talk about it directly. And notice, remember that when I sat there and said, Heller didn't distinguish between Derringers and single-shot front-loading, muzzle-loading type pistols, or cap and ball, or Glocks, or revolvers. Here again, this judge gets it. Lawfully bearable pistols. Well, what are all these pistols that have braces on them? Be they an FN, FAL type, an AR type, a Ruger PC carbine, an MP5 type. What are they? They are bearable pistols. They are all protected. Here is, not only does he go to modify or the right to repair, but here he has gone to all bearable pistols, all lawfully bearable pistols. So on its face, he just gutted what would be the Illinois semi-auto ban on pistols. Doesn't matter if it has a threaded barrel. Doesn't matter if the magazine attaches outside the pistol grip. Doesn't matter if it holds more than X number of rounds. Doesn't matter about any of the attachment bullshit the state put in their law. He just gutted that in his decision in Texas. So let's go on. The increased control and precision to pistol fire materially lowers the probability of potential lethal misfire and collateral damage, as well as being outmatched by or falling victim to dangerous assailants. Hey, this guy gets the concept, right? Such safety-improving modifications are especially critical for permitting disabled and weaker persons to fire pistols more easily and more safely and comfortably to accomplish a more proficient and exacting self-defense. Again, the word modify. Continuing on, the history interwoven with the right of the people to keep and bear arms indicates that the Second Amendment's text has a long incorporated the right of personal gunsmithing, the right of private individuals to modify or acquire modifications to lawfully bearable firearms so as to increase their accuracy and safety for a more effective exercise of self-defense. Bingo! Touchdown! You know, for the state, do not pass go, do not collect $200, go directly to jail. No. Here they say gunsmithing is a protected right under the Second Amendment's text. This is exactly what I've been arguing about. If it is covered by the text, and our job as advocates, as litigants, as whatever, our job is to make this 27 words of the Second Amendment, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Got to take a drink. Got to cool the pipes down. Our job is to make those 27 words read like the frickin' Encyclopedia Britannica. And here, gunsmithing under this judge's decision is now protected activity. That means the acquisition of parts, the activity, what comes out of gunsmithing. Well, what was that phrase they coined? Ghost guns? Oh, let me see if I can figure out where. Yeah, all right. Continuing on, it gets better. For example, in order to sustain themselves against large and well-supplied British military throughout the Revolutionary War, Americans relied on gunsmiths, individuals that know how from working on their own arms, and Americans who were willing to learn the art of arms manufacturing. Analogous to the role that stabilizing braces play for contemporary pistol owners, founding era gunsmiths involved modifying lawfully bearable pistols with extended grips and rearward stocks to facilitate greater stability, control, and accuracy in single-handed self-defense fire. The court is persuaded upon this record that the Second Amendment's text and history presumptively guarantees plaintiffs Mock and Lewis the right to modify lawfully bearable pistol arms with rearward stabilizing braces for the purposes of improving performance attributes necessary to successful armed self-defense. Game, set, match. Done. Everything I've been telling you guys ever since this thing started, and when I held off on the right to repair and getting our briefs done and not wanting to tip the state off too much. But guys, there it is. It's right there. A federal judge just agreed with everything I've been arguing for the last 9 months on the right to repair. And this is why in the case with FFL Illinois, we went after parts and guns to expand those 27 words. It wasn't just guns and mags. And we can have that discussion again at some other point. But this is playing a three-dimensional chess game. This is not checkers. This is not just throw it up on the wall and see what sticks. You know, a big kudos, a big hats off to FPC on this win today. I didn't read all the briefs. I don't know how much they actually argued some of this, but this judge gets it. And I'm certain that we will be filing a 28J letter in our case to advance this claim down the road. Now, here we are. We're already past 15 minutes. And so I'm going to cut this off here. I will do another dive into this video or into this decision out of the 5th District Court to bring up the other things. But he touched on common use. He touched on dangerous, unusual. He touched on pistols, as we've already talked about. No, this is a freaking grand slam on our issues that are before the court in the 7th Circuit Court of Appeals. And I want to see how Justice Easterbrook would argue against this, because this judge makes a very, very compelling case for all of it. Guys, as always, thank you very much. Please copy, hit the like button, smash the subscribe button, copy, paste, share this across your social media stuff. Please, as always, share it, get it out there. We are knocking on 10,000 subscribers. That is only because all of you like the information that I put out here. I get it. Sometimes I get a little bit behind, but today knocked off a little early just so I could get this information out to you, because I think it's so important in how we're just going to kick teeth in on the state of Illinois at some point in time. I would be remiss if I did not stop and pause for a moment. It was October 3rd today. It is the 30th anniversary of the Battle of the Black Sea, more commonly known to most of you as Black Hawk Down. And having met some of the guys that were there, Paul Howe in particular, here's hoisted one to the guys that we lost that day due to the political incompetence, cowardice, and immoral ineptitude of some of our political leaders. But those great warriors, those brave men, it's it's a shame we lost them. They are not forgotten. And for all those guys, here's one to you. With that, as always, frag out.